Guardianship is a legal process designed to protect vulnerable persons from abuse, neglect, including self-neglect and exploitation. Guardianship provides for the person's care and management of his or her money while preserving, to the greatest extent possible, that person's independence and right to make decisions affecting his or her life. Guardianships are created for a variety of different reasons. People become incapacitated due to disease, injury, or mental impairment. No matter what the cause, the decision to seek guardianship is often painful and difficult for the alleged incapacitated person and his or her family members. Guardianship removes certain rights and privileges from an incapacitated person, referred to as a ward. An incapacitated person can be a minor or an adult. The guardianship statute defines an incapacitated adult as a person who, because of physical or mental condition, is substantially unable to provide food, clothing, or shelter for his or herself, care for the individual's physical health, or manage their own financial affairs. There are different types of guardianships. A guardian of the person is appointed by the court to take care of physical well-being of an incapacitated person. A guardian of the estate is appointed by the court to care for an incapacitated person's property. Often both a guardian of the person and a guardian of the estate are appointed, and this can be the same person. Guardianships are either temporary, permanent, full, or limited. The role of guardianship is to provide care and protection to an incapacitated person, known as the ward. All guardianship in the state must be registered with the JBCC. Texas law requires that a guardian file a report each year that covers a 12-month reporting period. Texas law also requires that reports be filed within specific reporting periods for all wards. A guardianship must be created by the court through a formal appointment process. In Texas, guardianship usually includes hiring a lawyer, filing an application with a court, attending a hearing, having a judge decide if a guardianship is necessary, and appointing a guardian and posting a bond. Since establishing a guardianship affects a person's rights, it is important to know the implications of guardianship and explore other alternatives. This can only be done by effective processes and protocols administered on a consistent basis. There are many alternatives to guardianship that give people with disabilities support to make decisions without taking away their rights. Supported decision-making agreements. Texas law recognizes supported decision-making agreements as an alternative to guardianship. Supported decision-making agreements allow people with disabilities to make their own decisions and stay in charge of their lives while receiving the help and assistance they need to do so. Formed in the fall of 1992, the Texas Guardianship Association is a professional nonprofit organization dedicated to educating professional, family, and volunteer guardians, as well as legislators and the general public on ethics, standards, and best practices related to court-appointed guardianships and its alternatives in Texas. Visit texasguardianship.org to learn more about our work to educate involved professionals, consumers, and the general public regarding guardianship and its alternatives. The production of this video was funded in part by monetary grants and contributions. TGA expresses its thanks to the Texas Bar Foundation, Harris County Resources for Children and Adults, the Harris Resources Foundation, and Antec Civil Engineering.